Welcome, everyone. Thank you for being here. Just a word first on how this is going to go. Jeff and I will have a conversation for about a half hour, and then we will open it up for questions from all of you. We have two people with microphones, and we'll take questions for about 20 minutes. Impeachment questions are allowed. Jeff, first of all, I just want to get something out of the way right at the beginning. You were our commencement speaker in 2013 when your daughter Ellen graduated. And,
Just by coincidence.
right.
It
And
happened to be that year.
after promising not to embarrass her, you embarrassed her.
I did.
So
what are fathers for?
Let's just get that out of the way. Could you just acknowledge your daughter?
Ellen Toobin, there she is. Hi, beauty.
All right.
Ellen loves her some Mac, too. But she got married last summer to a fellow, Eric Dodd, a fellow graduate of the class of 2013. So go to Mac, find a spouse. Of whatever gender you like. That's all good. So that's, yeah.
So I want to start with a question that is not directly about the Supreme Court. That's been on my mind for a long time. One of the things I hear a lot is a series of complaints about the institution of tenure. Why do faculty members who get tenure essentially get guaranteed jobs for the rest of their careers? Why do federal judges get lifetime appointments?
Well, the specific answer is the Constitution says that judges shall serve during good behavior, which in practical terms means during behavior that's not bad enough to get impeached and removed by the Senate, and that's it's pretty bad.
Actually never happens.
It never happens. Interestingly, it has happened for federal judges a couple times in the past 10 years, and the last time it happened, the chief prosecutor of this corrupt judge in the South was Adam Schiff in his first term as a member of the House. But in practical terms, they had been criminally prosecuted. That's why they were impeached. But I mean, the idea is, and frankly, I think it's a sound idea, was that if you want judges to be politically independent and not responsive to popular opinion in the way that the democratically elected branches of government are, you need to insulate them from political pressure. Now, in the 18th century, when the Constitution was written, people were more or less expected to die in their 50s because that's what people did. And so life tenure usually meant 10 years, 15 years, whereas today, fortunately, we live in a world where people routinely live into their 80s, and presidents who want to leave their mark on the judiciary are appointing younger and younger judges. So 30 and even 40-year terms are now becoming, if not routine, much more common. And that's led to a lot of questions about whether life tenure is a great idea.
And in some ways, it's turned that original idea on its head. That is, the notion that a lifetime term would give you independence from being politicized has now turned into judges' appointments to the federal bench, and particularly the Supreme Court, being hyper-politicized because both parties recognize that it's probably the longest-term impact they could have on the policies of the country.
That's true, although I like to warn about sort of good old days-ism of, particularly when it comes to the Supreme Court, the idea that there was some sort of politically neutral period in the past. It is true, it is a very politicized moment now, but the Supreme Court has always been a political institution, and presidents have always tried to have a very specific ideological impact with their appointments. So, yes, we live in a very polarized political moment, and that's reflected in our in the judicial confirmation process. But through most of American history, not all of it, that was often the case as well.
So would you see what I would describe as the current relative predictability of the way the justices will vote as more typical than an aberration in the history of the court?
It is. There is this mythology that presidents are surprised by their how the justices they appoint turn out. And the examples that are often given is almost always the same example, which is Dwight Eisenhower, who appointed Earl Warren and William Brennan, who turned out to be very liberal. Now, I think we can say this about the presidency of Dwight Eisenhower. It was a long time ago, And the fact that you have to go back to Dwight Eisenhower to find serious surprises on the fact suggests that that is not that's not routine. It is true that George Herbert Walker Bush was somewhat surprised by David Souter, but if you look, for example, at the 9 justices on the court now, there's not a surprise there, and I think that's been true basically since World War II, with the exceptions of a couple of the Eisenhower justices.
So walk us through some of the most important cases or issues that you think the court will be examining over the next year or two.
Okay, well, you can sort of look at that in the short term and the long term. I mean, the short term, obviously, it does seem like they are going to get some sort of Trump scandal-related issues. I mean, for example, just this week, the Second Circuit Court of Appeals here in New York said that the New York City District Attorney, the New York County District Attorney, could subpoena Trump's accountants for his tax returns.
Right.
And that case is very likely to be appealed to the Supreme Court. If I were Cyrus Vance, who was the DA, I would be very pleased at that prospect, because I think out of all the issues, it's a pretty easy one.
And they have precedents from both Nixon and Clinton.
Yeah, the Clinton v. Jones, which was Clinton giving a deposition in the Paula Jones case, the Nixon tapes case from 1974, and also, the risk that judges legitimately think about, am I going to interfere with the operation of the presidency? These tax returns relate to the period before he was president. The president doesn't have to show up to testify. It doesn't interfere with his life. And presidents have revealed their tax returns as a matter of routine since the 1970s. So the immediate parade of horribles that you could conjure up is very difficult. And I actually think there would be at least 5 votes, if not more, to get these for this subpoena to be upheld. Other cases get more difficult. Whether Don McGahn, the White House counsel during the first couple of years of Trump's term, can be forced to testify before Congress. That gets more to the heart of executive privilege, and that case may wind up before the Supreme Court. So that's one constellation of cases. Also, you have President Obama had the DACA program, which allowed the so-called dreamers, the people who were brought to the United States as children and raised here by parents who came here illegally, whether they're allowed to stay in the country. That case is going to be argued very soon. That's a very important case. But in the longer term, the issues are sort of bigger and I think more profound. The most obvious of which is abortion. President Trump did something very important, and I think actually admirable in a way, where when he ran for president, he said, "Here are 10 people I'm going to apply. I may apply to the appoint to the Supreme Court," which was a message to his would-be supporters. This is what you're going to get, and he said, I am going to appoint justices to the Supreme Court who will vote to overturn Roe versus Wade. And what I think he meant by that was he's going to appoint justices to the court who will vote to overturn Roe versus Wade. And I think that's what he's done. And I think Roe v. Wade will be overturned in the next few years. and so I think that's, they certainly a profound and important issue.
Just
Yeah.
before we move on from that one,
Yeah.
is your
Because
thought...
everybody's not depressed enough.
Right, well, that seems to be the theme through all of these big questions
Yeah,
events.
yeah.
The last one was about whether democracy will survive, so it could be worse.
But Minnesota is probably one of the last places to be swallowed up by the oceans when the climate changes, so that's good.
And we do have water.
Right, yeah, lots of water.
Do you think that they will overturn it in a kind of blanket way, or do you think that they'll be a little bit more indirect about it and chip away at enough of it so that it is essentially moot, given the fact that they do seem to have, or at least Robert seems to have, some sense of the public view of the court and might not want to do something that is so unpopular with the majority of the population, or do they just not care?
No, I think, look, this has been the great conservative crusade of the last 40 years to overturn Roe v. Wade, and I think, that's what they want to do. I mean, this will be the great victory of their judicial philosophy. Now, let me give you an example. In 2016, Anthony Kennedy's second to last term on the court, there was a case that came out of Texas where Texas had passed a law that said basically that all doctors at abortion clinics have to have admitting privileges at nearby hospitals,
Right.
and that abortion clinics themselves have to have sort of the kind of surgical equipment that's like a full-fledged hospital.
And it closed most abortion clinics in the state.
Correct. And the Supreme Court, 5-4, with Justice Kennedy in the majority, said, this is an undue burden, which is the current standard, and that's unconstitutional. And Stephen Breyer wrote the opinion, and that was the law of the land. Okay. Kennedy retires. Gorsuch, first Gorsuch replaces Scalia. Kavanaugh replaces Kennedy, and Louisiana essentially passes the exact same law a year or two ago. The case is now coming up. The Supreme Court grants cert and says, we're going to hear this case, and they're going to hear it sometime, I think this fall. You don't take that case if you're just going to reaffirm a decision from just 3 years ago. They're going to, I have every expectation, they are going to either in fact or in name overturn the Texas decision. Now, will that overturn Roe versus Wade? No. But it will be one of those chips that will lead to the inevitable result. And of course, and we haven't talked about this yet, Mitch McConnell has made it clear that notwithstanding the Merrick Garland precedent, if there is a vacancy next year, they are going to fill it. And, Ruth Ginsburg is 86 years old, and, 86 is not the new anything. Notwithstanding her, enormously strong constitution and, seemingly invincibility to every disease known to humanity. But, he may get another appointment. And at that point, it doesn't matter what John Roberts thinks.
Right.
So anyway, that's...
So just before I let this go, one of the little mental games I play with myself is, how evil can Mitch McConnell get? So just let me ask you a hypothetical. If a Democrat wins the presidency in the 2020 election, and there were to be a Supreme Court vacancy that developed for whatever reason between the election and the inauguration of a new president, do you think McConnell would try to force through a new Supreme Court justice?
I don't think he could. I mean, that would be too short. I mean, if it's between
practically
November...
speaking, or because he has a conscience?
No, well, I mean, just, you would... For one thing, I mean, even Mitch McConnell would agree you have to have confirmation hearings. And, I think, Antonin Scalia died on February 12th, 2016, with almost exactly 11 months left in the term. So I think... if there is a vacancy sort of after July, August. I think that will sort of become pretty much impossible. But if there is a vacancy, anything up to probably the political conventions, McConnell will try to fill in.
Right. An issue that is of great importance to institutions like Macalester is affirmative action.
Right.
What's your prediction on what happens to affirmative action over the next couple of years? Because I can tell you that most of my colleagues think it's going to be gone.
I think your colleagues are right. I mean, again, there was a case in 2016. I mean, people forget 2016, the year that of the vacancy, the year that there were 8 justices on the court, was kind of a liberal moment at the court. There were 4. The court was split 4-4, but that meant that Kennedy had more power than usual, and there was an affirmative action case where they reaffirmed the University of Michigan case, where Justice O'Connor's opinion from 2003, where she said, in effect, colleges and universities may consider diversity as one factor among many, going back all the way to the Bakke case in 1974, where Lewis Powell said that race was one factor. It can't be the only factor, it can't be a quota, but race can be one factor that is before that universities consider. This is an area where John Roberts has been very much on the conservative part of the court. I mean, there are areas like Obamacare and certain issues where the census case last year, where he's been in the center. But that's not true on affirmative action. When they struck down the Seattle and Louisville school district cases, these are relating to high schools and lower schools, he said in a famous phrase, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race, which means to him, any consideration of race by any entity in making a decision. That's what he thinks, and I think there are 5 votes for that position.
Just on Roberts, there is a lot of debate about the extent to which his view of the history of the court, his role as an institutionalist, might affect the way he thinks about certain decisions. Are there, you cited the instance of Obamacare, which could come before them again.
Some version of it.
Would that be an example of a case where you think his view of the court as an institution might actually lead him again to save it?
It might. Well, I mean, you call it saving it. The conservatives don't think of like liberals' decisions as saving the court. They think of like, let's get rid of that crap.
Right.
So I mean, you got to remember that's the frame we're talking about here. I think Chief Justice Roberts is not Samuel Alito. He is not Clarence Thomas or Gorsuch or Kavanaugh. He is also not Stephen Breyer. I mean, he is not Sonia Sotomayor. He is a conservative. I mean, he is the author of the Shelby County case, which essentially ended the Voting Rights Act. He voted with the majority in Citizens United in all those campaign finance cases. So the idea that he's like, going to come out of his shell as some moderate is not one that I think is realistic. However, the Constitution refers to his job as Chief Justice of the United States. He is not Chief Justice of the Supreme Court. He is Chief Justice of the United States. And he knows that, and he's aware of that, and he recognizes that he is the custodian of the court as an institution that has to be respected as well as followed under the law. And so he does not want to see the court lurch in such a way that the court becomes discredited. I think the number of cases in which that's a relevant concern is small. Mm-hmm. I mean, the Supreme Court decides 75 cases a year. 10 of them get any sort of public attention. 3 of them people pay a lot of attention to. And the justices know that too. And so he's not thinking about the institutional reputation of the court in every case.
Right.
But, you also have to keep in mind, the court's current makeup is not fixed in stone. I mean, if the president gets to replace, Justice Ginsburg or Justice Breyer, who is, a sprightly 80, but still 80, the variables change completely, and Roberts becomes, in some profound sense, irrelevant.
So, which is kind of a natural lead to a question that has always puzzled me, which is why Democratic voters and Democratic candidates don't seem to focus more on the Supreme Court when they make decisions. I mean, it seems as if, I mean, you mentioned the fact that when he was a candidate, Trump said, these are the 10 guys I'm going to choose from. They're all chosen by the Federalist Society. You know exactly what you're going to get. And that is something that was really important to the people who voted for him. The issues are important, deeply important to Democratic voters, issues like abortion, affirmative action,
Gay rights,
healthcare, same-sex marriage, and yet...
Well, and it's not just same-sex marriage. I mean, just you think about issues that are coming down the pike. Many of you, I'm sure, are familiar with the Colorado bakery case, where the baker, who was a religious person, said, "I will not bake a cake for a wedding cake for a same-sex marriage." And the court sort of ducked the main issue on that, and they decided on a different. But there are cases coming up all over the country under the rubric of religious freedom. Photographers who won't take pictures of same-sex weddings, motel owners and innkeepers who will not let gay couples stay in, caterers, business people who will not do business with gay people. And this is a major issue to the right wing, that, what they call religious freedom. And those cases are working their way through. And I think that's going to be a big deal, where you're going to, these issues came up in the civil rights movement, where, people said to the courts, and even in good faith, we believe that God has preordained the separation of the races, and it is our religious conviction to honor that in our business. And the courts overwhelmingly and repeatedly said, you open for business, too bad. You want to keep people out of your home for racial reasons, help yourself. You can keep them out of your church, help yourself. But if you open a business, you have to admit everyone. And that principle is very much at risk. And I just think people need to think about that. And I don't remember what the question was before I started on this particular rant.
The question
why
is,
do Democrats not care?
Simply put, why do Republicans think about it so much and Democrats think about it so little?
It is a measure of my influence and importance as a journalist that I have been pointing this out for literally decades to no effect at all. It's a mystery to me, and this is not, if you look at the I've written about this, if you look at the websites of Joe Biden, Elizabeth Warren, I happened to see Cory Booker at CNN the other day. I was talking to him about, almost nothing about the Supreme Court. At the Democratic Convention in 2016, Barack Obama gave a speech as the outgoing president. Hillary Clinton gave a speech as accepting the nomination. Neither of them mentioned that Merrick Garland was sitting there, awaiting confirmation. Neither of them talked about the Supreme Court. It used to be, when I started writing about this issue, the explanation I was given was, well, candidates don't talk about it because the swing voters don't care, and the campaigns are pitched to swing voters. Well, Donald Trump proved that Republican voters care a lot, and the reason why Donald Trump is supported by over 90% of Republicans, and particularly evangelicals, is not because evangelicals think Donald Trump's life is such a model for them and their children and how he's lived his life. It's because he has delivered for them on what they care about. And that's something that is just different in how Democrats. Now, maybe it will take Roe being overturned. That Roe is, has been such an organizing principle for the right. Maybe the end of Roe will be an organizing principle for the left, but I'd hate to think that's what it takes.
What do you think about the notion of packing the court? As far as I know, I think the only candidate who has talked about that is Buttigieg.
Pete Buttigieg, yeah, and well, I mean, there are various ways of thinking about packing the court. I mean, there have been for a long time proposals for sort of staggered 18-year terms so that each president would get two. And in light of what's gone on with what a lot of people don't realize is that the number of justices is not fixed in the Constitution. It's fixed by statute, right? Saying Congress could change it tomorrow. And all through, up to the presidency of Ulysses S. Grant, the number of justices did fluctuate somewhat. The Congress hated Andrew Johnson so much that when a Supreme Court justice died during his tenure, they simply cut the number of justices so he couldn't appoint anyone, which is not the worst idea, I think. But Franklin Roosevelt, who faced an existential crisis in the United States in terms of the Great Depression and the failure of the Supreme Court to approve a lot of the New Deal programs, did a court packing plan in 1938, which proposed to add a justice for every justice over 70, sort of to help them with their work. I mean, it was a pretty transparent, and it failed by just a handful of votes in the Senate. Now, one of the advantages of being elected to the presidency 4 times is, you get to appoint 8 Supreme Court justices, and that took care of his problem. I think fundamentally it's a bad idea because it would lead to an arms race that Democrats think, oh, let's add 5 justices and then all our problems will be gone. But then, a Republican will be elected president someday and then they'll change the number. I think, because of Roosevelt's failed court packing plan, there has been a stigma associated with changing the composite or the makeup of the court in terms of numbers. And I sort of think you better to stick with that.
Right. Just 1 or 2 more questions, and then we'll open it up. And this one is about the court and gender. I read, and maybe you did too, a really powerful piece that Dahlia Lithwick wrote about the Supreme Court. She is, as some of you may know, the reporter who covers the Supreme Court for Slate. And she says that she can't now bring herself even to go into the building because there are 2 members of the Supreme Court who have been credibly accused of sexual misconduct.
Or as I prefer to think about it, 40% of the Republican appointees to the Supreme Court have been incredibly accused of sexual harassment.
And my attorney's son pointed out to me something that I didn't know, which is that the attorneys who plead cases before the court are overwhelmingly male. Are we misled by the fact that there are 3 women on the Supreme Court into thinking that it is somehow a balanced institution? Or how should we think about the issues of gender in relation to that court now?
Well, I like to sometimes talk about the Supreme Court by the numbers. There, as you point out, there are 6 men and 3 women. First time, the 3 is the most women there've ever been. There are six Catholics and 3 Jews. There are no Protestants on the court. While Justice Scalia was on the court, there were representatives of 4 New York City boroughs on the Supreme Court. Justice Scalia
was diversity.
Yeah, right. Justice Scalia was from Queens. Justice Sotomayor is from the Bronx. Justice Ginsburg's from Brooklyn, and Justice Kagan is from Manhattan. Tragically, Staten Island has been unrepresented on the Supreme Court. But I mean, and I do those numbers, and then I say, and there are 5 Republicans and 4 Democrats on the Supreme Court. That's what matters. That's what matters. This is a moment in our political history where the parties are more polarized than they have been throughout much of certainly our lifetime. You know, there used to be a lot of moderate Republicans in the Senate, in our beloved Minnesota. You had people like Rudy Boschwitz and David Dernberger. You had Robert Packwood and Mark Hatfield in Oregon. You had Lowell Weicker in Connecticut and Robert Stafford in Vermont. And, you know, I mean, you had like a lot of John Heinz and Chuck Percy. They're gone. They're completely gone. There used to be a lot of moderate Republicans on the Supreme Court. Sandra Day O'Connor, John Paul Stevens, David Souter, Potter Stewart, John Marshall Harlan, all gone. Because they're gone in the world. There's no such thing as moderate Republicans anymore. And so, you know, when I hear Dahlia say that about women, I mean, I think she's right, but that merely, the Supreme Court simply reflects the current makeup of our parties. And there's one party that believes institutionally that abortion should be illegal in the whole country. And that's who they appoint to the Supreme Court. I mean, it's that's how I think of it rather than strictly speaking in terms of gender.
Right. All right, we're going to open it up now for questions. We have 2 microphones. Tony has one over there, and Glenn has one over there. Since we are recording this, please do wait and speak into the microphone.
Hi, Dan Yarosh. The one issue that seems important is gerrymandering. It goes on the state level, and state courts decide, North Carolina, whether it's legal or not. Is this going to be a Supreme Court issue, and how do you think they would rule?
Well, it was. I mean, it was a multi-decade crusade to get the Supreme Court to say that partisan gerrymandering is a violation of the Equal Protection Clause or other clauses in the Constitution. And this was an area where Justice Kennedy was the swing vote. And through like at least 3 cases and maybe more, he said that, well, it could be a violation of the Constitution, but I haven't seen it in this case. So he sort of kept the idea alive. Well, last year, in an opinion by Chief Justice Roberts, he drove a stake through the idea. He said the federal Constitution is not implicated by partisan gerrymandering. We will never consider a case. I mean, it was one of the most tragic opinions, I think. And Justice Kagan wrote a very powerful dissent saying, well, I disagree with the result here, but you state courts should look to your state constitutions because that could be a ground on which to overturn this pernicious practice. And just to, I mean, gerrymandering is so much responsible for our current politics because our state and local, congressional seats, state representative seats are designed in such a way that only one party really has a chance. And so you get the more radical, the more right-wing, the more left-wing, and you lose the chance for more moderates to win. I'm pleased to say that at least the state of North Carolina has taken up Justice Kagan's suggestion, and under the North Carolina Constitution has said that gerrymander has to be redone, and that can't be overturned by the Supreme Court. Pennsylvania, similar situation. The Pennsylvania Supreme Court said under the Pennsylvania Constitution. So there has been some progress on gerrymandering at the state level. California has, eliminated it. But California, there are no Republicans anyway, so you can't gerrymander a Republican seat there, other than a handful anyway. But but that issue is closed now for the foreseeable future under the United States Constitution.
During the Kavanaugh hearings, there was sort of talk on the internet about waiting a certain amount of time for the possibility of removal of him. What is the reality of that conversation for him or for anybody else under similar, maybe not exact same circumstances, but you know what I mean?
Well, under the Constitution, the provision for removal of a Supreme Court justice is the same as it is for a president, which is impeachment by a majority of the House, and then 2/3 of the Senate has to vote for it. I mean, regardless of what you think of the merits of the Kavanaugh situation, it's quite apparent that it's not happening. I mean, there is no impeachment move afoot, and much less majority support for it in Democratic House, much less 67 votes in a Senate where there are 53 Republicans. So, the issue is simply just foreclosed.
Yes,
I think that microphone is not working. I'm a
It's
television
working?
professional. I know these things.
can you hear me?
That's better.
Is that
yeah.
better? This is probably a softball question, but I'm curious.
Then it's more than welcome.
I'm interested in the role of the Supreme Court, the Chief Justice, if there is indeed a trial in the Senate. And this comes out of some news reports that I've heard about Mitch McConnell wanting to fast track a trial if there is such a thing. And yet I believe the Chief Justice has a role in that. Would you clarify what that is?
Well, under the Constitution, I covered the trial of Bill Clinton. I'm like getting so old, it's kind of disturbing. But I was in the Senate during every day of Clinton's trial in 1998. And I have, Ellen, I have that cool thing where I kept my tickets you had to have a ticket. And so I kept every day's ticket and I have it framed. It's like a great nerd thing. And but Ellen can testify, it's there. Under the Constitution, the Chief Justice presides as the judge in the trial. The other thing that's interesting about Senate trials is that all 100 senators are required to be in their seats at all times, which if you've ever seen how the Senate functions, they're never in their seats at the same time. I mean, you're walking around, they're schmoozing, whatever. It drives them insane because, the idea of politicians having to listen as opposed to talk for hour upon hour, makes them crazy. The structure of a trial in the Senate is very much up to the Senate itself. And now, what happened in the Clinton trial is that they had some depositions of witnesses that were taken by senators, but off, not during the trial, and the transcripts, but there were no witnesses before the full Senate. I mean, basically what happened in 1999 when the trial was held, is both sides found it advantageous to just get the thing over with as quickly as possible because they knew Clinton wasn't going to be forced out of office. The Republicans had just suffered in the midterm elections. They didn't want to extend this any longer than they had to, so that there was kind of a meeting of the minds between the Democrats and the Republicans. That's not necessarily the case here. I mean, there is a school of thought that says McConnell will try to use the trial to embarrass the Bidens, for example, to make sure that have Joe and Hunter Biden testify as witnesses, which I doubt either of them would enjoy very much. There was a lot of attention to Rehnquist's role. Chief Justice Rehnquist was the judge. He did almost literally nothing during the trial. I mean, he didn't rule on. There was one evidentiary objection, minor thing he literally just sat there and did nothing. I think it's likely that is what the Chief Justice Roberts will do. It's not like a trial in the sense that the judge has to preserve certain due process rights of the defendant. The Senate can make its own rules. So I mean, it's a great question, but I don't really know. I mean, there are a lot of things that have to be decided first before we know what role Roberts will have, if any.
So this may be a little
Oh, there you are. Oh.
this may be a little simplistic, but it strikes me that when any appointee candidate goes for hearings, they're always asked, how do you feel about historical precedent? And they always say, oh, yes, 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 we respect decisions that have been previously approved. And then they get appointed to the court and they do whatever they want. So is that accurate? It seems accurate to me, but I'm not asking you to opine on how Samuel Alito sleeps at night, but do you have any comment?
The answer is, you know, in 1987, Robert Bork was nominated, and Bork had a, you know, brilliant record as a professor, as a judge on the D.C. Circuit, and an outspoken conservative. And the senators asked him a lot of questions about his record, and he answered those questions substantively, and he was voted down 58-42. And subsequently, the lesson that has been learned is for the nominees to say as little as humanly possible in answer to questions. And you know, my favorite question that they duck, you know, they always say is, well, I can't answer that because the issue may come before the court. Well, that's why we want to know. I mean, but you know, and this applies to the liberals as well as the conservatives. They all duck in response to the Bork hearings, and they all, you know, pay lip service to precedent. And you know, and it is true that, you know, it's not like precedent is always so great. I mean, you know, it's wonderful that you know, liberals think, oh, you have to protect Roe v. Wade. They didn't feel that way about all the gay rights decisions that were overturned to get to the Obergefell decision. I mean, you know, there are a lot of precedents that liberals want to overturn and celebrate when they're overturned. So the idea that, you know, precedent is always right is I don't think anyone really believes that. But, you know, and it all comes down to ideology. I mean, you know, what really matters is what kind of ideology you bring to the court, and that is largely determined in the choice. The hearings are almost uniformly uninformative about what people actually believe, and that's by design.
Hi, I'm in class of 2014, and I wanted to know, given like the shift in our politics, like most people who are like left are actually more moderate. I'm really curious if we were to elect a Democratic president, do you think we will actually have like left-leaning, if they have a vacancy, that we'll actually have a left-leaning judge, or do you think that will still be more moderate and somewhat right-leaning?
It's a great question. I think a lot of the answer depends on what happens in the Senate. You know, if the Democrats retake the Senate, which at the moment is unlikely but not out of the question, and elect a president, I think you could get a very liberal justice through, like a very liberal justice, and I think there'll be a lot of pressure among, you know, Democratic interest groups, as well there should be. I think if Mitch McConnell is still the majority leader in the Senate, it could be a very different scenario, and you know, I can't imagine how brutal, you know, a Democratic nominee in a Republican-dominated Senate will be. But I mean, you know, there are lots of names floating around. Some are more liberal than others as prospective Democratic nominees. But I think the makeup of the Senate will have a tremendous impact on that. I mean, if you look, I mean, you know, it is true. I think the premise of your question that the Republican Party has moved farther right than the Democratic Party has moved farther left. I think that's true, but I also think the Democratic Party has moved farther left than it's been, certainly under Clinton and even under Obama. So I think, you know, if, you know, just to name the sort of the three leading candidates at the moment, and God knows, I don't know who's going to be the Democratic nominee, much less if that person will win, Biden, Warren, and Sanders, any of those three, if they become president, will name someone pretty darn liberal to the Supreme Court, and perhaps more than one if there's more than one vacancy. But whether that person can get through, that's a tough call. I don't know.
Alex McBlyde, class of 2002. Mr. Toobin, you made a very provocative statement early on in the discussion that Roe v. Wade would be overturned. I think that created a lot of anxiety in this crowd in particular. I wanted to test that a little bit. First of all, I think we've had a conservative majority in the court for a generation or more, and yet Roe v. Wade is still the law of the land. I realize the court's drifted a little bit far to the right, but a lot of these prior nominees were against Roe v. Wade, and yet it's still the law of the land. Question two is, we're still in a very political environment, and the Supreme Court is the apex of that. It's a political body. Don't you think, like John Roberts with the ACA, political pressure will ultimately suppress an overturning of Roe v. Wade?
Well, you are certainly right that the court. Particularly in 1992 in the Casey decision, I think there were 7 Republicans on that court, but they upheld what they called the core of Roe v. Wade in that decision. But I think you have to take into consideration the evolution of the party. That court in 1992 had Anthony Kennedy, Sandra Day O'Connor, John Paul Stevens, David Souter. These were moderate Republicans. The court that will evaluate the current the current abortion law in Louisiana is Clarence Thomas, Samuel Alito, Brett Kavanaugh, Neil Gorsuch, and John Roberts. That's a very different court because it's a very different Republican Party, and that's why I reached the conclusion I reached. That was the Roe v. Wade. The second question was about. I'm sorry.
Well, the question is, would
political pressure?
Right.
Yeah, I don't know. I just don't think that John Roberts and the rest of them are certainly aware of the political inflammatory nature, but they think Roe is wrong. They have a view of the Constitution. Roe is not just sort of a landmark. It is a decision with constitutional reasoning based on precedent, and it's implicit in the right to privacy. They don't believe that the Constitution protects the right to privacy. Privacy is not mentioned in the Constitution. If you are a textualist, as they call themselves, based on the text of the Constitution, there's something liberals believe in called unenumerated rights, which means rights that are not spelled out in the Constitution, like privacy, like a freedom of association, that are implicit but not spelled out. Conservatives don't believe that. And so, I think ultimately they feel like the chips will fall where they may. And it also is worth pointing out that if Roe v. Wade is overturned, abortion does not become illegal in the United States. It means that states are allowed to ban it. And the fact is, it's almost illegal in much of the country already. But it is also true that because of medical advances, there are ways for women to get abortions now that involve, pills through the mail and travel to other states. And frankly, one of the reasons why I think Roe v. Wade is especially doomed is because of the way contraception availability is in this country. The people who need abortions, by and large, are poor people. It's not 100% true, but it is much more a lower middle class and lower class problem than it used to be, which is another reason why it's particularly, wealthy people in whatever state they live in will always have access to abortion. as they did even when it was illegal. So, I mean, all of that leads to my prediction, but it's a prediction. And
So we have time.
fortunately, I work in cable news where there is no accountability for
Right.
being wrong.
We have time for one more question.
Hi, Elizabeth Adenolfi, class of '94. I'd like to say two things first. I don't know if people know, but the Texas abortion case, the clinic network that was the subject of that case is owned and run by a Macalester alumni, Amy Hagstrom Miller. So we have a huge
Is it
connection.
still up and running?
Yeah, they've closed some of them down, but I do believe some are still up and running. I know that I think the one in Austin had to close. But I was at MAC with Amy, so it was really amazing to see a woman from Macalester having such a huge impact on the law. Second thing is, I would like to echo what was said at the beginning and thank President Rosenberg. When I found out you were leaving, I was profoundly, profoundly sad. You have had such an impact on Macalester. It is a very different institution than when I was there, and only in more positive ways. And I think we could all say that's largely due to your leadership. And we appreciate your voice. You have been publicly vocal on issues that matter so much to this community when other college presidents have been silent, on the immigration ban, on DACA, on trying to help and protect Macalester students who've been affected by decisions of this administration. And we thank you for it, and you will be so, so very missed.
I plant one of those at every one of these events, just so you know.
God, I can't top that. God, it's just like, I'll go ahead and ask a question if you want, but.
Well, I have a question that's a little scarier than overturning Roe v. Wade.
Oh my
we've
God,
been
I'm not
hearing-
depressing enough for you?
Well, there's
no,
been
let's go,
a
let's-
lot of what used to be a very fringe theory, and we've seen questions coming up where judicial candidates are not affirmatively and overwhelmingly and enthusiastically saying, of course Brown versus education is the law of the land. Of course Brown versus education is the constitutional lodestar of equal protection in this country. And now that we're seeing the chipping away under the guise of religious freedom, attacking protections for gay rights and same-sex couples, do you see an opening where equal protection based on race, where you had people like Rand Paul who said, well, you know, if you have a private business and you don't want to serve Black people, well, don't you have the right to do that? This very fringe, you know, right-wing judicial philosophy seems to be creeping more and more and more into the mainstream. Do you see vulnerability there?
Well, let me answer that in a positive and a negative way. Let me start with the negative way, which is I don't really think they are going. The reason they're saying they're not answering the Brown question is not because they want Brown overturned. It's because they don't want to be asked about other cases. They want to have a blanket refusal, because they say, okay, you think Brown is correct, what about Roe v. Wade? What about Obergefell? So that's the reason. I don't think Brown is a particular target. But what is a target, and this is something I should have mentioned earlier, is the whole structure of the administrative state. If you look at what Brett Kavanaugh is most famous for in the legal world, it's telling administrative agencies that they can't do what they're trying to do, which means they can't limit pollution. There's something called the Chevron doctrine, which gives administrative agencies a certain degree of flexibility in interpreting the laws that they're operating under. One of the big conservative agenda items is that to get rid of the Chevron doctrine and to try to cabin the power of administrative agencies. And that's something, you know, to look forward to. So that's the negative side of what's going on. The positive side, and I think this is really an important thing. You know, the government is not this country. This country is this country, and this country's changed in a lot of ways. And when Mike Pence, tried to, limit gay rights when he was governor of Indiana, you know who it was who stopped him? It was the big corporations. It was Eli Lilly who said, we can't recruit people to this state if you have your, terrible anti-gay policies, and Pence backed down. And if you look at, what the country is, has moved on certain areas, like immigration. I mean, Trump has been a threat to a lot of institutions. And a lot of institutions have responded pretty well, I think. And PBR, President Brian Rosenberg, reflects that I think many academic institutions, when it comes to immigration and issues like DACA, has said, we're not going to let you come here and take our students away. And churches have said that, and religious institutions. And the press has been very active and vocal and successful, I think, under Trump. And I see no prospect of any retreat in any of those areas. So, yes, it is true there are a lot of efforts underway. But, when you have major companies like Eli Lilly, which is not exactly, what you think of when it comes to the resistance, saying, you know what, you can't discriminate against gay people anymore. You just can't do it. That's a reflection of how the country's changed. And, Samuel Alito can't change that. So that's a happy thought.
All right, we're going to end on that happy thought.
Someone asks.
We're going to grab that. First of all, please join me in thanking Jeff for being with us this evening.